So the ATF is now desperately trying to prevent more companies from joining into the Texas case where a federal court has already granted an injunction against the ATF's enforcement of their new rule on frames and receivers. So let's talk about this. But real quick before we jump into this video, if you agree that the ATF needs to be done away with, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Arms Directory. Arms Directory is the place to go if you're interested in a social network and a marketplace that actually is pro-Second Amendment. Feel free to go to Arms Directory, post your favorite gun pictures, talk prices, find local events, and post videos about your builds and also other information relating to firearms in a place that is Second Amendment friendly. So if you're interested in a social network that's actually pro-Second Amendment, I will leave a link down below in the description section to Arms Directory, and thank you again to Arms Directory for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing civil rights attorney in the state of California with an emphasis on the Second Amendment and our right to keep and bear arms. I've been part of Second Amendment litigation at both a state and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is to give you greater insight into the inner workings of the Second Amendment, various litigation, so that you better understand what is going on in these legal battles and the battles over your right to keep and bear arms. As I mentioned in the intro, in this video, we're going to be talking about how the ATF is now desperately trying to prevent another big loss in the Texas case challenging the ATF's new rule on frames and receivers. Blackhawk Manufacturing Group, aka 80% Arms, is now trying to join this case as a named plaintiff, but the ATF desperately does not want that to happen because there is fear that the preliminary injunction, which the court has already granted to one specific manufacturer, will also then be granted to 80% Arms. The case we're going to be talking about in this video is Vanderstock v. Garland. This is a lawsuit filed in the Northern District of Texas against the ATF and their new rule on frames and receivers that went into effect in August. In this case, Vanderstock, the plaintiffs requested a preliminary injunction from the court to enjoin, i.e. to halt the enforcement of the ATF's new rule. On review, federal judge Reed O'Connor granted a limited preliminary injunction against the ATF. In reaching his decision, he stated, ATF's new definition of frame or receiver is facially unlawful. The issue here, he stated, is whether ATF may still regulate a component as a frame or receiver, even after ATF determines that the component in question is not a frame or receiver at the time of evaluation. Congress has not extended ATF's authority so far, he stated. That the firearm part is designed to be, or may one day become, a frame or receiver does not change the fact that in that moment, it is not the frame or receiver of any such weapon. So looking at the ATF's rule on frames and receivers, this judge found that it's facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. So he granted a limited preliminary injunction in favor of one of the plaintiffs, Tactical Machining. Since his injunction was limited in scope, he himself recognized that the injunction, which protected only the manufacturer, Tactical Machining, would still put the customers of that company at risk of felony prosecution if they purchased any of these items. Then there was a battle in this case to expand the scope of that injunction. The plaintiffs argued that that injunction should be expanded to protect the customers of Tactical Machining and also that members of FBC should be included in the protection as well. And that also included other manufacturers who were members of that organization, including Blackhawk Manufacturing, which is 80% Arms. So Judge O'Connor reviewed the arguments and issued his order, granting the expansion in part, but also denied the expansion also in part. He expanded the injunction to protect the individual named plaintiffs in the case and also the customers of that one specific manufacturer, Tactical Machining. However, the court denied the expansion to protect FPC and also its members, which included Blackhawk Manufacturing. This meant that Blackhawk Manufacturing, as a member of FPC, would not be granted the expansion of the preliminary injunction to protect them from the ATF's actions. But because of this case, Blackhawk Manufacturing is now seeking to intervene in the case and become a named plaintiff, and therefore they filed a motion to intervene. A motion to intervene is a legal mechanism where a third party can join into an already ongoing case. That third party was originally not involved in the case whatsoever. They are not a named plaintiff, but once a case is going, they can then actually join a case. They can become a plaintiff, they can become a defendant, or they can become a third party who maybe has an adverse position to both the plaintiff and defendant. So in this case, Blackhawk Manufacturing wants to join the case as a named plaintiff. However, the ATF desperately does not want another manufacturer to join in as a plaintiff because that exposes them to risk of the injunction potentially being expanded to also protect a new manufacturer and also the customers of that new manufacturer, like what happened with Tactical Machining. And this would also be significant because 80% Arms or Blackhawk Manufacturing is a very large manufacturer of these items. In opposition to the motion to intervene, the ATF first argues that the request is not timely, and that is the basis in which they are opposing and actually arguing to the judge that he should not allow Blackhawk Manufacturing to join this lawsuit. They argue when the plaintiffs in this action filed suit, Blackhawk declined to join this action or to join in the plaintiff's motion for a preliminary injunction. Nor did Blackhawk choose to file its own action. Instead, Blackhawk deliberately waited to see if this court would issue preliminary injunctive relief. Only after the court did so has Blackhawk belatedly sought to intervene in this case, citing alleged interest that it has repeatedly declined to take any steps to protect until well after the effective date of the rule and only after a favorable ruling for another manufacturer. These are not the actions of an entity facing any alleged death sentence. The ATF goes on to state that the court should decline to reward such tactical behavior, and these unusual circumstances further counsel against determining the motion to intervene to be timely. In response to the ATF's argument, Blackhawk states that defendants characterize the timing of their motion as tactical behavior that the court should not reward. The court in City of Syracuse reached a conclusion contrary to the defendant's argument, finding that the length of time, which was 4 months, between Polymer 80's knowledge of the action and its interest to intervene does not weigh heavily against a finding of timeliness. Further, the City of Syracuse court noted that there is no specific length of time that has been deemed to be the appropriate time period in which to file a motion to intervene, and cited other illustrative decisions. They go on to state that Blackhawk filed its motion to intervene within a month of the final rule going into effect, which was in August, and promptly filed their motion to intervene after the court issued its preliminary injunction with respect to tactical machining, at which time Blackhawk, the manufacturer, became aware of its interest that would no longer be protected by the original parties. Here they argue essentially that they filed their motion a month after the rule went into effect, and also they filed it right after the court issued that original limited preliminary injunction, saying that they were only going to protect that one specific company, Tactical Machining, and they were only going to protect that one company from the ATF's enforcement actions of that rule. Blackhawk argues that at that time, when they found out that the injunction would only protect that one specific manufacturer, that is when they decided to file that motion to intervene, and that's when their interest in this case actually kind of arose, and that's why they filed it, and that is timely in their belief. They then go on to state that further, this litigation remains in its infancy. And then Blackhawk kind of walks through where this case currently stands. They state that there has just been an amended complaint that's been filed. The ATF hasn't even responded to that amended complaint. There have been no dispositive motions. They're still scheduling this case, and also a trial date has not even been set in this case as of right now. They state defendants' opposition fails to demonstrate anything more than speculative, minor inconveniences to a group, the U.S. Department of Justice, which has unlimited resources. So this is a new battle that's currently going on in this ATF frames and receivers case that's coming out of Texas. The goal of Blackhawk Manufacturing is to intervene in the case and become a named plaintiff in this case. They will then likely seek an injunction or the expansion of that injunction that's already been granted, that's already protecting Tactical Machining and its customers. They will seek for that to be expanded to also protect them as a manufacturer and their customers as well. So that's a quick rundown of what's currently going on in the case against the ATF's new rule on frames and receivers. Another solid win could come out of this case, so we will have to wait and see whether or not Blackhawk Manufacturing will be allowed to be a new plaintiff in this case. But if we get any more information, I will let you all know. If you have any questions, like, for example, the question that people are saying that my glasses are fake, which obviously they are not fake. I don't know why people would say that. But if you have any questions like that, go ahead and leave them down in the comment section down below, and I'll try to answer the best of my ability. Now I got to clean my glasses because I smudged them all up. Also, like this video and like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.